So in order, the other thing that we want to get into are is the concept of time, place, and manner restrictions. It is possible for the government can base prior restraint on time, place, and manner, which is time of day, where you are, and the manner that it's presented. So the rules are that for a law to be constitutional, another set of 4 that you need to mark and remember. This also will appear on the test sometime. This is if you want to look at a law and determine if you think it's going to pass constitutional muster. These are the 4 reasons why state and federal legislation will be declared unconstitutional under time, place, and manner restrictions. So this is that content neutral thing I was talking about that's sort of like, that was related back to the school case. Rules have to be content neutral on their face in their application. The rules must not constitute a complete ban on one kind of communication. So for example, you can't completely ban all magazines. That would be under number 2. The third one, this is extremely important. You might have done these 2 in your law, but if it doesn't answer to a substantial state interest, there is something, this is going back to that phrase that we've heard so many times about the substantive evil that government has the right to try to prevent. That's what it's talking about here. And so then if you have this, you've got 1, 2, and 3, then it's got to be narrowly tailored. Remember, we don't want to curtail or censor any more speech than we have to in order to achieve this. So that's the whole point. It's to narrow it down. The courts are not going to say that there aren't going to be certain types of speech at certain times that we have a right to curtail because it's really protecting some interest that is vital. But we just can't have this blanket, nobody can say whatever. It's got to be very narrowly tailored, which narrowly tailored means it has to be very defined exactly what constitutes the elements of this particular kind of speech that you're going to let prior restraint take hold of, and it's never going to happen. So these are the 4 rules you have to know. And this is where the court says we're going to have this strict scrutiny concept in judicial review. This means that the government has to prove that compelling interest. They can't just say, oh, well, we have a very substantial compelling interest. Okay, prove it. Prove it. What are the consequences? And it's not just substantial, it's compelling. It means we are compelled to do this. Okay, what is the difference between, oh, it'd be nice, oh, I'd like to, I'm compelled to? What's the difference? How do I compel you to read the chapters? I make you take a test. I compel you. It'd be nice if you said, oh, it'd be so nice. Do you have more on this topic? I really like to read more about this. No, so remember, yeah. And then we go into the forums here. We're almost done, I swear. This is where we get to the different forums. There are traditional public forums. These are, now, we don't see this very often anymore, at least not in small towns, that a street corner could be a public forum. But if you live in a town where a street corner has traditionally been where people gather to talk about ideas, and it's always been that way in your community, then it would be a public park. Before we got so much media and stuff, if you wanted to know anything or even be entertained, you had some sort of pavilion at your local community park, and this is where the bands would come, this is where the politicians would come, this is where everybody would come to hear what was going on. Because you didn't have CNN, and you didn't have Fox, and you didn't have TV or the internet. So the only way you got anything was if the people actually showed up in your town. So wherever that traditionally happened would be your traditional public forum. This is the most First Amendment protected place ever. Now, on our campus, this campus is only 40 years old. I'm not sure if we have a traditional public forum here. If we do, where do you think it might be? You guys are the ones that are out on the campus. Is there a place where you guys gather to find out what's happening, or just to chat? And no, you go online and you're on Facebook. So I don't know. Probably the UC, yeah, because now we've got the auditorium, and we didn't always have that, which is nice that you actually have it. But yeah, we send stuff over there. We take your blood over there. We do other things over there. So yeah, could be I don't know where it was in the past, maybe the library before we got the auditorium. Then we have designated public forums. This is where the government creates something specifically for these kind of activities. This is where you might have a convention center that the local government sponsored and built, and this is where we have those things. These are city owned. It could be the fairgrounds if the city owns them. This is government owned. And because the government owns them, you as the people and a member of that community, as citizens, you sort of have an ownership in that. Designated public forums are the next level of protection. That does have First Amendment protection. However, the government has greater power to use those time, place, and manner restrictions if they don't want certain speech to be there. Mm-hmm.
In a situation like that, so say like you have like I forgot what you just said, like
A traditional, a designated.
Not a traditional, a designated
Yeah.
by a city, and say that city is very like right wing. If you had two speakers that were vying to speak there, and they allowed the right wing speaker to speak, and then prevented the left wing speaker.
See, now you've got a problem with it's not content neutral. Okay, content neutral means I cannot censor speech based on whether I agree with it or not.
Oh.
Yeah, so that's why that one is like number one on the list. It has to be content neutral because that keeps people from just letting speech happen there that they like.
Well, it just seems really easy. It seems like they would be able to control the time slots you get, for example, and they just like, oh, we're all booked up. It seems like really easy for them.
Well, and this is where you have to make sure that, and I'm not saying that could not happen, but this is where they're going to open themselves up to someone feels like they are consistently excluded or given the dog times, that they would have a lawsuit that they could bring forward. That it apparently is not content neutral, and we also look at how the language. I mean, there are some cases where, and I think one of them is coming up where the mayor got to decide who got to have a sidewalk vending place, and you had to have your vending booth meet certain guidelines, and the guidelines were not even published. It was whether or not the mayor liked your booth. Well, that's not going to pass. It did not pass constitutional muster because it was too much on one person. There were no published rules, so you didn't know what you were up against. Then we have the designated public forum. Designated public forums. These are the ones that the government has created. The intent has to be determined by, you have to intend that it's going to be a public forum. You actually have to have a policy and a history that you've used it thusly, and it has to be a natural, the property has to match what you say its purpose is for. It has to match, in other words. Now, you can have public property that is not a public forum. Things like a prison. It is not a public forum. It never will be. It was not meant to be a public forum. Military bases, subway stations, where the mailboxes are at the post office, even though people gather there and they chat, it is not a public forum. Airport terminals, etc. And then the one with the private property, this is not owned by the government, that's hence it's private. There are no First Amendment guarantees here. So, if you don't want someone on your lawn saying things that you don't like, you can make them leave. Now, there is a problem though. Sidewalks are public area, so they can stand on the sidewalk, which is why if you don't want the press in your front yard, all they have to do is retreat to the sidewalk or the street, and they can hang out in the street all day. because they're now in public area, but your property, you do have a say-so. Now, this to me is an interesting thing too, though. A shopping mall can be owned by a private company, not by the government. Therefore, the mall has the right to say who can be on that property and who may not be on that property. Which is why if you want to go do a news story or any type of project at the local mall, you need to go and get permission from mall management, because if they don't want you in there with a camera, they can make you leave. So don't be going, oh, First Amendment rights, freedom of the press. No, it's private property. You may not, you have to get permission. If you don't leave when they ask you to, they could have you arrested. So knowing what type of forum you're at can be extremely important before you start claiming First Amendment rights and freedom of the press, because you don't have it everywhere you go. All right. I know many of you had some Son of Sam questions. I'm going to save them for Tuesday. So remember, you've got till Tuesday at 11 to do the quizzes on Chapter 4 on libel, and bring your cognitive maps with you to class. Hooray!